seated. Thank you. Thank you both for allowing us to move this up. We had some scheduling issues yesterday, so thank you both for arriving early and being here. This is case number CACV 130430, KCI versus Holmwright et al. For the party's information, these proceedings are being recorded, both audio and visually, and hopefully in a week or two you'll be able to see yourselves on YouTube and have your 20 minutes of fame. The podium will indicate how much time you have left. Appellate, you may reserve a portion of your time for rebuttal. If you'll tell us when you approach the podium how much time you'd like to leave for rebuttal, we will try not to horn in on that time. We'll try to keep an eye on it. If the clock says you've got 10 minutes and you want 5 minutes for a rebuttal, that 10 minutes includes your 5 minutes of rebuttal. Okay. As you approach the podium, please say your name, who you are representing. We have read the briefs, read relevant portions of the record, and conferenced this case before coming into oral argument today. So, with that in mind, and I guess there's a cross appeal. So, you may also reserve a portion of your time for your cross appeal. Okay? And if you'll tell us again, we'll try not to horn in on your time. So, okay, with that in mind, you may begin. And welcome to Arizona. I hear you're here from Nebraska.
Yeah, I get down here a lot, but I got to get back tomorrow.
Okay.
But good morning, and may it please the court, counsel. My name is Jason Bruno, and I'm here on behalf of appellant KCI Restaurant Management LLC, who I will refer to simply as KCI. I doubt I'll use it, but I would like to reserve 5 minutes for rebuttal if I could. KCI brought this lawsuit derivatively on behalf of SVP Restaurant Management LLC, who I will refer to simply as LLC, or as SVP, excuse me. This case arises because corporate counsel got involved in a dispute between 3 members of an LLC. Holmwright is that corporate counsel. It sued on behalf of SVP, one of its members, KCI, to collect a $651,000 debt that was never owed by KCI. It was owed by a third party dating back to 2004. And to do this, Holmwright paid themselves attorney's fees of over $317,000. Now the problem arises because Holmwright never sued the correct party, the entity that owed the debt, and it allowed the statute of limitations to expire. We're before this court.
Do we presume that they're following the instructions of their client in doing that, or they just get to say, hey, the client says, hey, somebody owes us money and we'll sue whoever we want to?
Arguably, but there's no evidence of that. In fact, prior to filing this suit, we asked what directions or advice or warnings were given. And if you look at the attorney opinion of Mr. Lerner in the record, he says that it probably wouldn't be a breach of the standard of care if the clients were duly advised. But we have no evidence at this point or at any time that that is true. We're here before this court because the Superior Court dismissed.
Did you then get KCI get permission from the LLC to sue Holmes, or doing it independently just to protect the LLC?
No, we got an express, we don't want you to sue them. We were denied by both the other 2 members of SVP and by Holmwright themselves, which is why we brought the derivative suit, because SVP itself wouldn't act and told us pretty adamantly that they weren't going to act. We're here.
Then how does KCI then have the authority on SVPs? Because as I understand it, the other 2 members had voted KC out of the LLC.
Well, that's a good question, and we dispute that. We dispute there was ever a valid or lawful vote for several reasons.
Well, but that's the underlying action. And
yes.
If, in fact, you win the underlying action, maybe you get to resurrect this claim. But at least on a derivative, if you're not a member of the LLC, how can you ostensibly protect SVP's action?
Because we were a member of the LLC at the time of filing the derivative suit. Just because
You were a member
Yes,
at the time?
absolutely. Yes, just because the other two members sit there and say, well, we don't consider you an LLC or a member of the LLC, that doesn't count, that doesn't matter. There's laws that they have to follow, there's an operating agreement that they have to follow, and somebody has to validate that we were lawfully removed and we were at one point or another not a member of SVP. And that,
How, under law, how do they have to validate that other than, a vote duly held by the members of the LLC?
well, that would be one way, but they would have to do it in accordance with the operating agreement, and there would have to be proof in the record before this court or some other that that was the case.
The other two deem that your client is not a member, right?
They're denying it in this lawsuit, yes. But for purposes of the judgment on the pleadings, we allege that we were a member at the time of filing suit. But more importantly, there's another lawsuit pending where we're going to have a jury trial or we're going to have some sort of trial where some fact finder is going to determine whether or not we were a member of KCI at the time this lawsuit was filed. So a couple of years down the road, we could have a determination that we were never kicked out, they never followed the procedures, and we were always a member of SVP. But then you're going to have the decision of the court below on a judgment on the pleadings that says we weren't, so we're going to be precluded from bringing a $651,000 claim based on the judgment on the pleadings. That's not the standard. And that's kind of why we're here today. We alleged in our lawsuit.
If you're successful, can't you then, if you're successful below, can't you then refile and bring the claim at that point in time without a worry? Because then it's a definitive determination, obviously, once it goes through any appeal process. But
We would be able to, but the statute of limitations will be long expired, and I'm sure Ms. Gilbride will raise that as soon as we try to bring a new suit. I mean, 2 years from the malpractice occurred in about January 2011. So if this case gets dismissed, I mean, there's never going to be any recourse for any malpractice that HomeRight may or may not have committed. But in this case, we think that the Superior Court should have stopped at our allegation in the complaint on a motion for judgment on the pleadings that we were a member. Should have stopped there, denied the motion for judgment on the pleadings, but it didn't. It went farther, and it considered about 75 or 80 pages of select portions from another lawsuit or several other lawsuits that the three members have been engaging in going back since about 2009. So after we made our derivative claim saying, hey, SVP, go sue the lawyer for not collecting this bill, they all got together and they tried to expel us. We disagree that that ever happened, and we filed a lawsuit saying that their attempt to do so was unlawful and asking for a declaratory judgment that whatever they did or tried to do was invalid, and that we at all times were a member, including when the suit was filed.
But, counsel, what happens if the opposite happens and that you lose your action below and that your client was properly expelled? How does that affect this litigation?
Well, unless the court goes with our argument that the derivative statute needs to be interpreted, that it should be judged at the time the derivative demand was made, we're probably out of luck at that point. And then the Superior Court would be somewhat correct, and we wouldn't be able to bring a suit because we weren't a member. But that's a big step. I mean, we frankly think that we got a good shot before the jury or the court, especially after they consider when we were removed and who orchestrated the removal. We sent a derivative demand saying, hey, company, go sue the lawyers for not collecting this debt that we billed for back in 2004. And nothing was done. And afterwards, instead of giving conflict warnings or anything like that, HomeRight called a meeting together to try to expel KCI. One of the reasons is so they could raise the very defense that was successful before the Superior Court, which is we didn't have standing. We don't think that's correct or appropriate. So,
well, how does the statute support your argument that you just have to be a member at the time a demand is made? Because it doesn't say that. You have to be a member at the time you bring the derivative action. Clearly,
Your
The two
Honor,
of you don't agree.
Your Honor, I agree with you that the statute says that, but I don't think the legislator could have contemplated this scenario. I mean, because the whole,
It doesn't matter whether they did. They said the only way you can bring is if you're a member.
Yeah.
So if you get tossed, you know, legitimately or otherwise, then you're not a member and you can't bring it.
and that's why we would ask this court, if it needs to get there, and we don't think it does, we think all this court needs to do is look at the allegation of our derivative claim that says we were a member at the time, and that requires reversal of the judgment on the pleadings before. I mean, there was no trial below. There was a motion for judgment on the pleadings, which is one of the most difficult standards there is. But if this court agrees with the Superior Court's determination, then I think it needs to take a good look at this statute and the principles behind why it allows derivative actions. It allows derivative actions for this very scenario where when you have one person who doesn't have control to do anything getting either squeezed out or abused by the other members. In this case, it was the other members with who was supposed to be acting as corporate counsel. So I think somebody needs to take a look at this and say, well, wait a minute. These guys made a derivative claim. It was a legitimate claim. There was clear malpractice here. And instead of acting on it, and by the way, there has to be a time period that you give the company to act and bring suit themselves or to consider the complaint, there has to be some sort of equitable basis for the court to intervene and say, well, you were once a member, you made a demand. They can't come in and kick you out for the very purpose of stopping you from bringing a legitimate suit to bring or to seek redress on behalf of the company because the people who are supposed to be running it aren't running it fairly or aren't running it well.
Where would that standard of equity be found in the statute?
I don't think it is, frankly, Your Honor. I
So we
don't
would
think
have
it
to
is.
create that as an exception to the plain meaning of the words.
I'm not sure they're that plain, but yes, I think that it would need to be a judicial exception to that was created for the fact scenario. But again, I don't think you need to get there because basically what the lower court did is it said that KCI made a judicial admission that they weren't a member. Well, there's several flaws to that argument. The first one is nowhere do we ever admit that. All we did was file a lawsuit and said, hey, they tried to kick us out. We think that's unlawful. We want the court to do something about it. And we said we also want a declaration that whatever they did was invalid and shouldn't stand. But second, and this court has stated, nothing that's done in a different proceeding could be conclusive. It can't be conclusive. It could be evidence. So if we did admit somewhere that KCI was not a member, which we didn't, they could raise that against us, but we're allowed to rebut it, which we did. We submitted the affidavit of Scott Selden, the manager of KCI, who says, I've always been a member. They never kicked me out. They didn't pay anything for the interest. I didn't give it away. They didn't follow the procedures in the operating agreement. And we believe whatever they did at this meeting was invalid or unlawful. And again, that has never been determined any place, and it has yet to be determined and probably won't be for another couple of years the way these parties are fighting amongst themselves. But none of this evidence was considered by the Superior Court. So at most, all they could have done is transfer it into a motion for summary judgment where there were clear factual issues on whether or not KCI was a member at the time of filing this suit.
Well, but if the court is relying on pleadings or items that it's taken judicial notice of, the law seems to allow it to do so without converting it from a 12C motion to a 56.
But maybe that's true. But if they do, the case law has to come in that says if there's a judicial admission raised, that the other party is entitled to rebut it. And that's what we did by putting in the evidence of Mr. Selden, putting in evidence that HomeRight previously filed a complaint that alleged that KCI was a member of SVP. And we also pointed out the answer in this case where SVP raised a defense and said, well, you should have filed a derivative claim on behalf of SVP against the third party that owed the money. Well, inferably, if we have the ability to bring a derivative claim against the third party that owed the money, we have the same ability to bring one against KCI. And if I may, I'd like to switch a little to the counterclaim, where HomeRight seeking attorney's fees. We don't believe that's...
You know, you get to, in your rebuttal, you get to address what she says in attorney's fees. So you can do it now,
Okay.
but if you want to, I'm just telling you, you're going to be able to come back up and after she argues the attorney's fees. So it's up to you.
All right, well, I'll take a little direction from the court. But the bottom line in this case is since HomeRight began representing SVP as corporate counsel, SVP has lost $317,000. It went to their attorney's fees. They've lost a claim against a third party for $651,000, a claim they knew about. They had the invoices submitted by their clients dating back to 2004. Yet they sued KCI, one of the own members. And for its efforts, or for HomeRight's efforts, SVP has recovered zero to date. The only remaining cash that SVP has as a result is $425,000. That's $425,000 that KCI safeguarded to keep it away from the other members and their counsel. KCI didn't spend a dime of that money. It's sitting with the Superior Court below pending determination of the other matters. Now that's the very same money that Ms. Gilbride's going to stand up and say that KCI somehow converted, which they clearly didn't. They protected it. KCI has always done the job that HomeRight as counsel for SVP hasn't done, which is protect the entity, not one member, not two members, the entire entity, because that's counsel's job. The bottom line is we believe there's plenty of evidence in this case that shows that that KCI was a member of SVP at the time the derivative lawsuit was filed. We believe that granting a motion for judgment on the pleadings was inappropriate and incorrect. We would ask for a remand, ask for the denial of the motion for judgment on the pleadings, and ask this court let KCI proceed derivatively to collect the $651,000 that SVP lost as a result of HomeRight's clear-cut malpractice in this case.
Should we just issue a stay if we're going to remand it and say, let this action then determine what may happen? Because if you lose in the underlying action, then this becomes really a nullity.
I really don't have any issues if the court were to issue a stay pending the ultimate decision of this issue, because it will be litigated and decided somewhere, and it will be determined conclusively, and certainly not on a judgment on the pleadings, whether or not KCI was a member of SVP Restaurant at the time it filed this derivative suit. I mean, we're mainly worried about the statute of limitations at this point, but we think based on the case law and the standard of motion for judgment on the pleadings, that this court should reverse and allow our case to proceed. If anybody has any additional questions, I'd be happy to answer them.
We'll reserve the remainder of your time for your rebuttal
Thank you very much.
and response to the attorney's fees.
Good morning, Your Honors. Eileen Gilbride for the defendants HomeRight, Home, and Welker. I think he's talking about a completely different case here. Or the story that he is spinning is so off the charts. I'm flabbergasted. The trial court was absolutely correct in dismissing this lawsuit. It's just not possible for a party to actively litigate a claim that it was wrongfully expelled from a company at the same time as bringing a derivative claim on behalf of the company it was supposedly wrongfully expelled from. It's just not possible. You can't have it both ways. You were either wrongfully expelled from a company or you weren't. And if you're going to claim that you were wrongfully expelled, you can't bring a derivative claim. Now, if judicial estoppel is the reason for it is to protect the integrity of the system, then it certainly applies here. Allowing KCI to maintain these two lawsuits is itself irreconcilable. It doesn't matter that KCI asked as a remedy in that lawsuit, the SVP lawsuit, to be reinstated as a member. There is no such remedy. It's not an available remedy because they have, if you want to, first of all, there's no authority that I could find in Arizona or in the entire country where a court has ever reinstated a member that has been expelled from a private company. If they
be a damages claim?
Exactly, and that's why the judge denied their TRO, because they had an adequate remedy at law. That's their remedy, is to seek damages, and that's what they're actively litigating. They can't do that and also bring a derivative lawsuit on behalf of the company it's suing for wrongful expulsion.
So, if they're successful,
If they are successful,
in the ancillary litigation, they're just going to get damages.
That's right.
But they're still out.
they're still
Out
they're
of
still
the
out,
lawsuit.
and maybe they get damages if they win, but they don't get to be a member again, because no matter what happened, whether they said there was no notice or there was no this or there was no that, that doesn't allow them to sort of nunc-pro-tunc be reinstated as a member. It doesn't happen that way, and they haven't cited any authority to that. So it doesn't matter that they asked for that as a remedy. You can't make yourself a member by asking for an improper remedy in the underlying lawsuit.
Counsel, so if they acted inappropriately,
They meaning SVP?
yes, then it's just a breach of
Contract. That's right.
action.
It's damages. Now, I suppose in theory, someplace, somewhere, someone could try to bring a mandamus action to force the company to reinstate it. But in order to bring a mandamus action, you have to have no adequate remedy at law. And they obviously have an adequate remedy at law. They're pursuing it. Okay. So Mr. Selden's affidavit doesn't change this at all. All he's doing is making a conclusory legal assertion that KCI is a member. Well, it's not. It's been expelled. It's kind of like letting a party create a question of fact by making an affidavit that controverts prior testimony or prior judicially noticed facts. You can't do that. So that doesn't create a fact question that would require reversal. Mr. Lerner's affidavit has the same problem. All he said that the justification for expelling KCI has to be determined as a matter of contract. Well, okay, we don't care what the justification is here. All we care is that they were expelled. You're going to talk about the justification in the damages case in the other case, whether they get damages or not. So that's not a matter for this case. There is no evidence. Oh, and going back, another reason these affidavits don't create a fact question is that I don't even think the court can consider them. They're not judicially noticeable. What we attach to our motion for judgment on the pleadings are judicially noticeable pleadings from the other case. Affidavits aren't judicially noticeable. So I don't even think you can consider them. But even if you do, they don't create a fact question anyway.
Could the court consider them and say, I'm going to treat it, though it didn't? Is a 56-1 motion?
It could have, but it wouldn't matter, because no matter what they say, they can't recreate membership in KCI. It was still wrongfully expelled, according to them. It was expelled. And it's inconsistent, and it sort of perverts the judicial process to even let them bring this lawsuit derivatively when they're also claiming they were wrongfully expelled. That's what judicial estoppel does. It prevents stuff like this from happening. I'd like to go on to the cross appeal because
Before you do that, let me ask you a question. Address his argument that they, if we affirm the trial court that their statute of limitations runs and they're never able to bring this derivative action again. Can you address that argument?
Sure. The fact of the matter is that SVP, the company, didn't want to sue its lawyers. It decided, no, we don't want to sue our lawyers for this. And so that is a decision that the minority member, when they were a member, has to live with. They made a derivative demand, please sue your lawyers. SVP immediately said, no, we don't want to, because you're the one who misappropriated all our funds. We don't want to sue our lawyers. And this actually gets into the cross appeal, because that derivative demand was made in June of 2011. KCI said, well, let me go back, and I apologize, but it does get into the reason why there is absolutely no reasonable cause for this lawsuit. SVP sued KCI in 2009. You misappropriated all these funds. Please give them back. Bad faith, punitive damages, attorney's fees. KCI, is having to defend this. 2 years later, KCI makes a derivative demand against SVP, its opponent. Please sue your own lawyer. SVP immediately says no. And we know this was alleged in the complaint here. SVP says no. That's 2011. 2 years go by. Does KCI, or 1 year goes by, does KCI itself sue HomeRight derivatively? No. Does KCI file the suit against the third party that it claims HomeRight should have sued? No. It goes along. What happens next? Judge Foster grants summary judgment against KCI for that $425,000 they said that they're safekeeping. They converted it. It's a judicial decision by Judge Foster. KCI converted those monies. That's why that money's in Superior Court, because it's being held. They converted it. After the conversion decision comes down, SVP says, you're out of here, KCI. You converted our money. We're expelling you. That was in July of 2012. July of 2012. KCI tries to stop it, saying, don't expel us, TRO. Judge Foster says, no, you have an adequate remedy at law. We're not going to stop this vote. The vote occurs, and in his memorandum for seeking a TRO, KCI says, if you don't stop this vote, we will lose our membership rights. That's exactly what happened. That's what they said in their pleading. The vote occurs, they're expelled. Then, 6 months later, what does KCI do? Oh, now they file this derivative lawsuit against its opponent's lawyers. Well, why didn't they make that derivative claim long ago when their demand was denied? Because KCI is the one who didn't pay those monies on behalf of the third party. KCI is not going to bring a derivative lawsuit against itself. Ask their lawyer, why didn't KCI bring that lawsuit after the demand was made and after SVP said no? Because they're not going to go sue themselves. Okay? But yet, what is KCI claiming in this case? KCI is claiming in this case that HomeRight failed to file the lawsuit against that third party that KCI didn't sue because its own client, HomeRight's own client, SVP, didn't want to. So they're claiming in this case that HomeRight should have filed the lawsuit, that their own client didn't want to, and that they didn't file themselves when they had the opportunity a year and a half before they were expelled. This sounds fishy? It does. You know why? Because this lawsuit is a ruse. It's a straw man that KCI cooked up as a bargaining chip that it could try to use to get SVP to drop that lawsuit. We'll drop this lawsuit, says KCI, if you'll drop that one. There has never been any reasonable cause for this lawsuit, ever. And if you want to know what's happened recently in that lawsuit, it's on the docket. It's not in this record, but it is on the docket. SVP's receiver, because now they're in receivership, just filed a report saying that SVP needs to be put into bankruptcy because KCI misappropriated $1.8 million from SVP. That's why KCI is trying to get the focus on some third party, because they're on the hook here. They want SVP to drop that lawsuit. And they used this lawsuit that had no reasonable basis to try to create a bargaining chip for that to happen. Now, I know that the standard is abuse of discretion for attorney's fees, and it is under that statute. But the judge here didn't say a thing about why he was denying the attorney's fees. He didn't find there was no reasonable cause. He didn't find that there was reasonable cause. All he said is that fees will be denied. I know that abuse of discretion is a difficult standard to overcome, but if we affirm this, all we are doing is encouraging trial judges to say less and less and less about why they're denying fees, because the less they say, the more they're insulated by abuse of discretion. And I would encourage the court to remand this case, to reverse the denial of fees, and tell the court, we need to know, did you find that there was reasonable cause for this lawsuit? Because if there isn't reasonable cause. And
Did you request the court to make findings prior to its decision?
I don't think we did, but we did ask for fees. We asked for fees on this basis. And I think that the failure to ask for reconsideration of the denial of fees, to say, okay, you denied us fees, but you didn't say anything. Could you please tell us why? Reconsider? I don't think that constitutes a waiver.
Well, I'm not saying that would constitute a waiver, but at least as you were seeking fees, to say, Judge, under 29833, you've got some discretion, but please articulate some findings for whatever reason you're going to issue.
I mean, I don't think it's required. It's not like a rule, whatever it is, where you have to, 50, whatever it is, where you have to request findings of fact, conclusions of law. And it happens all the time. A lot of the time, the trial courts just, they'll say denied, or they don't give the reasons. And I know that it's not a requirement, but it makes review by this court and by us impossible, because we don't know whether he found reasonable cause, which would be reversible, or no reasonable cause, but I just don't want to award you fees. There is no reasonable cause, and because that's an objective standard, we're encouraging the court to please reverse this so that it recognizes that there's no reasonable cause for this kind of a lawsuit, when at the same time they're trying to get damages for wrongful expulsion. There's no business filing this lawsuit. And I think if you ask KCI's counsel, why didn't they sue HomeRight themselves? Why didn't they sue that third party during that year they had the opportunity? He'll probably say, well, I don't know, or it doesn't matter. But it does matter. And this is why, because it shows that there is no reasonable cause. I'll save the time that I have for rebuttal if I need any.
Okay.
Unless you have questions. Thank you.
Now is your time to do rebuttal on your case and response to the attorney's fees.
Okay, thank you, Your Honor. Ms. Gilbride said that I was talking about a different case. She was just talking about a different case, talking about all sorts of matters outside of the record that I'm not going to respond to because I don't think it's appropriate for them to be addressed before this court. But that was one of the problems below, too. Ms. Gilbride wanted the court to consider everything they wanted the court to consider other than the evidence that we offered, like Mr. Selden's affidavit or like our very complaint. This was a motion for judgment on the pleadings. Nothing should have been considered below or before this court other than the complaint that's filed in this case.
Well, but the court can consider other pleadings in the court's possession, Maricopa County, that have been filed in that consideration without conversion and without relying upon any affidavits that you may have found.
But it does, but it has to give us the opportunity to rebut, which we...
Well, not if it's just taking judicial notice, as opposed to if there's something you said that was inconsistent with what you're saying now, and it was there.
I disagree, because if you look at the case law, including cases from this court cited in my brief, nothing that could happen in the other proceedings could be conclusive. So we're entitled to explain why there is inconsistencies. You also heard Ms. Gilbride argue that we had some inconsistency in some other case that precludes us from bringing this one. Well, that's not the law in this state. And I would cite this court to page 5 of my reply brief and the State Farm insurance case, where it addresses a similar argument. They say the essence of the doctrine of judicial estoppel is not merely that a party has taken inconsistent positions in judicial pleadings. If such were the case, our rules would not expressly allow a party to state in his pleadings as many separate claims or defenses as he has, regardless of consistency. The reality is it doesn't create a conclusion that we admitted something. We were entitled to rebut it. We did if the court wanted to go beyond the complaint. Ms. Gilbride also says that you shouldn't consider Scott Selden's affidavit because all he does is make a legal conclusion that they were a member of SVP. Well, let's look at the other side of that. All SVP and the other two members have ever said is KCI is not a member. That's never been validated or vindicated by any court. It's the same thing.
Except that that's what you're challenging below, which is wrongful expulsion.
No, what we're doing, that's part of it, but what we're doing is we're seeking a declaration not to be reinstated, but that we were never removed because that removal was invalid. And if that's true, and if somebody agrees with us, the lower court's decision would be catastrophic for SVP.
Because even if you succeed, you're not a member. You're just compensated for their improper action.
No, not if we prevail on our declaratory judgment and somebody says whatever they did was void or invalid, then we're back in. And nobody has dismissed that lawsuit yet. That's one of our prayers. That's going to be litigated. They didn't file a motion to dismiss on that claim saying your remedy is for damages. Absolutely not. That is still alive and still active and could be, and we think will be granted. One other thing. With respect to the motion for attorney's fees, no basis for this claim. Really? HomeRight had invoices in their hands from 2004 from a third party. They didn't sue. They let the statute of limitations expire.
But if the company didn't want them to sue, they don't have to sue.
Well, if the company didn't have to, if they gave express and proper disclosures about what the detriments would be of not suing, and that's what Mr. Lerner states in his affidavit, because the standard of care wouldn't be some attorney who's trying not to get sued to go to him and say, no, we're not going to sue them. He would have to explain the detriments as to what would happen if they didn't sue him, which would include you might not recover the $651,000 that we claim these people owed for 2004, and that's where the standard of care lies here, and that's where the breach occurred, according to Mr. Lerner. There's not any evidence in the record showing that what HomeRight did was correct. In fact, it's undisputed that what they did was not correct. I mean, there's expert testimony in there. But the bottom line is there was nothing improper about bringing this suit. They might get off on a procedural technicality because they kicked us out after we made the derivative demand, but that doesn't justify fees, and the lower court was correct in not finding that it did.
Well, should we send it back anyway and have the trial court explain why it did what it did? Just to, as much as you're saying we should create a judicial exception with the derivative statutes, couldn't we do the same in 29833 to say, because there's that language about whether or not the actions are reasonable, then the trial court should in fact articulate some basis for what they do.
Well, Your Honor, I think that would be inconsistent with the abuse of discretion standard, because on this record there's no showing of an abuse of discretion. But more importantly, we're asking the court to send it back and reverse the ruling on the motion for judgment on the pleadings, which we think was clearly incorrect. Thank you.
Thank you. We will take this matter under advisement and issue a ruling in due course. Oh, I'm sorry. I'm sorry.
Yeah.
We have a cross appeal.
Just a few
That's
little
okay.
comments,
Take your
and
time.
it won't take very long. On the judicial estoppel point, it's not just the statements in the pleadings that were attached to our motion for judgment pleadings. It's the existence of the claim itself that is inconsistent. Second, the we're back in if they win. They haven't cited to you one authority that says they can get back in. And finally,
They are asking for that as relief now?
they're asking it. It's improper, but there's no authority that says that they can have that, and they haven't cited that here.
Can't get both damages on a declaration?
No, they're not entitled to a declaration that they're back in. That's internally inconsistent too. And finally, the counsel said that there's no evidence that what HomeRight did was correct. We don't even have a party withstanding. We don't get to the merits. We don't even have a party that can make this claim. So I stand on my other comments and ask you to reverse the denial of fees and affirm the judgment on the pleadings. Thank you.
Thank you. Now we will take this matter under advisement and issue a ruling in due course.